Hello, therapists. Good morning, good evening, good night, good afternoon. Who knows exactly when you're watching this, but we're glad that you're here. For this fun-filled CEU today, Healthy Divorce Mediation 101, how therapists can prevent divorce wars and protect children. I am Michael Orrit, director and co-founder of the Orrit Center for Divorce Mediation.
Everyone. My name is Karen Orrit, and I am also co-founder and director of the Orrit Center for Divorce Mediation.
And today we have an hour of what is mediation? How does it work? How is it that we can help people avoid court, avoid conflict, avoid all of the negative experiences of divorce or legal separation? There is another way to do this. There is a healthier way to do this. And we want to focus on that so that you are educated about this process so that you can help educate your clients who are considering this process about it. And we're going to provide some really good information about things that you also might educate your clients on when it comes to their children's behavior. That's actually very normal behavior in many cases. Yet this is the behavior that can create child custody battles. So there's a lot that we're going to cover today. Where to begin? Kind of just want to talk about what is mediation. Mediation is where a third party, a neutral person, helps both the husband and the wife, the mom and the dad, have a conversation about all of the issues in the divorce or legal separation and helps them reach agreements on those issues and then drafts those agreements and then submits those agreements to the court so that the entire divorce process happens out of court. And instead of an adversarial process where people are lawyering up and fighting with each other, they're doing it in this cooperative, collaborative way where we're reducing conflict, helping them reach agreements, and hopefully setting them up for a healthier co-parenting relationship after the divorce.
Exactly. And Michael, what you're speaking to is what so many people do not know is that you can take care of your entire divorce process outside of court. You don't actually have to fight. You don't need to hire attorneys and have them battle for you. You can come in and we can help you reach agreements on every single issue, the same issues that if you did go to court, a judge would ultimately decide for you. Here, you are deciding your own agreements, and a judge is signing off on your agreements.
Let's really break that down. Let's really start with covering what the mediator is actually doing in the room, the mediator's process. The mediator's process begins with raising every issue of the divorce, right? Raising that issue, identifying it for the clients who, in many cases, are going to be online via Zoom, who might be in person around a round table with the mediator. So we're going to raise the issues. What are the issues? Three major areas of issues in any divorce case. First major issue is going to be assets and debts. Okay, think about things like the house, the cars, the retirement accounts, the bank accounts, credit cards. I'm going to raise as mediator the main issue, and then I'm going to also raise all the smaller issues, the details that relate to that main issue that both parents, both spouses need to be aware of and reach an agreement on, so they have a complete agreement about that house, right? What is going to happen with the house specifically? When is it going to happen? How is it going to play out? What special agreements might each of them need incorporated so that from both of their perspectives, it's the fairest and best possible agreement that can be reached? So first big area of issues, I'm going to raise every asset and every debt that exists. Second area of issues, sometimes very important set of issues, other times it's not an issue at all. It really depends on them, depends on the clients, depends on their individual financial circumstances. And it depends on the history that's led up to their current circumstances in terms of, will they be able to meet their own expenses with their own income after the divorce? That's the issue we call spousal maintenance in Arizona. Other states call it alimony or spousal support. And so, like I said, sometimes it's a very important set of issues. Other times it's not an issue at all. It depends, and we'll cover it in mediation. The last area of issues for parents is by far the biggest area. It's called developing a parenting plan in Arizona. All of the issues that relate to the kids. There are going to be parenting time issues. How are they going to share time with their kids? There are a number of required issues that Arizona says we've got to address. And there are also some very recommended issues that we cover that are going to create more stability and are going to reduce conflict, because parents are deciding these things now instead of not knowing what to do when they happen in the future. So a parenting time schedule is going to be very important, how they share time day to day with the kids, holiday schedules, vacation time agreements. How often are they going to review the plan? What happens if a parent relocates to another state? What happens if a parent during their own time is not able to care for the kids? Does the other parent have the right to care for the kids during that time before a babysitter is able to be called? So lots of parenting time issues that are raised and discussed. Decision-making issues are discussed. How are they going to make major decisions related to major health issues that come up with kids? Major educational issues. What school are they going to go to? Religious issues as well. So how are those decisions going to be made? And then finally, in the parenting plan, financial issues. We're going to cover child support. We're going to cover how are they going to pay for certain out-of-pocket expenses, like out-of-pocket medical expenses, like extracurricular activity expenses, educational costs. There are even some tax issues that we're going to cover to help maximize benefit to parents when it comes to kids and taxes. So the mediator is going to raise the issue, explain the issue. The mediator is then going to tell the parents the law. What does Arizona law say? And that's why we always carry with us the greatest hits of Arizona law. All of our mediators have this so that we can break this open and we can actually read the law with them and explain, what does Arizona think is most fair on this particular issue? So they will know, to the best of our knowledge, what's going to happen in court. But we always remind them they don't have to follow the law. They can come to whatever agreement they believe is most fair. And that's where we have conversations. So I raise the issue, I tell them the law, and then I help them have a very thoughtful, very efficient, in some cases, tightly managed conversation so that they can understand their options. I might let them know that if they want to follow the law, there are different ways to do that. I might hear from them what they would like to do and help them craft agreements or give them options that meet their own personal needs. And they'll talk about that, and we'll manage that conversation well so that they can reach an agreement.
Exactly. And during these conversations, this is where the magic of mediation happens. In court, one spouse hires their attorney, the other spouse hires their attorney. They make demands. I want this with parenting time. I want this. They battle in court, and ultimately the judge decides the agreements for their children. Whereas in mediation, we're giving our clients an opportunity to say things like, what are the personality traits of my children? What are their needs? Who's best to help them during the school nights of the week? Who's best to help take them to their soccer games on the weekends? These are the things that are not discussed in litigation. In mediation, we are open, we're having a conversation. We want to meet the family's best needs, and we want to help children thrive. And so parents are able to stay in complete control with support of a mediator guiding them through every issue. And this is all confidential. So you get the most creative, most beneficial agreements for your family that are going to affect your family long-term with the least amount of conflict. You get to be as creative as you possibly can in mediation.
Yeah, I mean, it's such an important point to really focus on the self-determination. Self-determination is the core of mediation, whereas when parents are litigating, they are relinquishing their ability to make decisions. The judge will decide these things for them. And what we understand is no one is ever happy with the outcome when it's ordered. We see the opposite when people are able to reach agreements in mediation because they actually own their agreement. They're going to comply with that agreement at much higher levels than if they're ordered to do something. So it's a very empowering process. Imagine that juxtaposition between a mediation room where parents are sitting there together and told, here's the issue, here's the law, here are some creative ways that other people have dealt with this. What would you like to do? What are your thoughts and ideas? How would you like to structure this agreement? Empowering for parents, even who are in conflict with one another, as opposed to just being stripped of that ability, having conflict really escalate, and then a judge ultimately deciding their future and the future for their kids. So we're raising the issues, we're explaining the law, we're helping this conversation unfold and helping them get to agreements on every issue, their best agreements possible. And then we are going to draft their consent decree. That's what it's called in Arizona, a consent decree. And this is the final legal document, right? It's the final legal documents. This is what is going to make the divorce final. Attached to it is going to be something called a property settlement agreement. This has all of their financial agreements, paragraph by paragraph. And it also has the parenting plan. This is what it is. It's a roadmap. It really is a plan, issue by issue, for how they're going to handle it when it comes up. And what we do is we email this to mom and dad, to husband and wife, and they review it. They make sure that we got their agreements correct. They could have this reviewed by their own legal advisor, by their own attorney if they want to, before they sign. And we actually have a resource for them to help them do that. But we'll talk about that in a minute. After they approve this and they're both ready to sign, we have a signing for them where they sign the documents, and then we submit it to court for them. So people in mediation with us, and we imagine elsewhere, are never going to court. They're never going near a courtroom, a courthouse. They don't have any interaction with the legal system. We're handling everything for them from the beginning to the end. That's a glimpse into the mediation process. Karen, things that I'm forgetting about the mediation process. Can you think of anything to cover?
Absolutely. So some advantages of mediation. Mediation is a fraction of the time. So where in court, hiring your own attorneys and battling out in court, you're going to see a court battle that could be 8 months if it is uncontested, which means that it's moderate conflict, but does not actually go to court, could be 8 months up to a year and a half, 2 years if the case goes to court. Whereas in mediation, you're going to see about 2 to 4 months for an entire divorce process. So that's a significant difference in one's life. Also, mediation is about 80 to 90% less expensive than hiring attorneys. Why? Because in mediation, it's a process. We're doing it together. At the RIT Center, we have a flat fee where you stay in control of your entire process from beginning to end. So our clients know exactly what to expect. Whereas in litigation, spouse A hires an attorney, pays about $5,000 to $15,000 in retainer fees. Initially, they're going to spend $5,000 to $15,000 in Arizona. Spouse B also hires an attorney and spends $5,000 to $15,000. Right there, they're both spending total more than they would have spent in mediation. And this is just to start the case. So once the attorneys begin the case, what happens is their $5,000 to $15,000 retainers, they deplete, and attorneys then do not do any more work than what is paid. So they ask for more money. And what causes a case to rise in cost is conflict. The more conflict, the more time, the more money. And that's when emotions run high and it affects the entire family. So mediation is 80 to 90% less expensive and a fraction of the time. So those are two very key points to know. And the third point is lower conflict. Mediation is more cooperative. It is healthier. And that's not to say that when you attend mediation, you're not going to have conflict. There is conflict. Divorce is conflict. There is something going on and they're not seeing eye to eye, and we are there to help guide them through. However, you don't in mediation have the added stress of fighting a legal battle. So it keeps conflict low. We help with a very guided process using many of the skills and techniques that therapists use to help guide our clients. So you're going to see lower conflict, and we're also taking children, if children are involved, into consideration, constantly putting children in the forefront of our minds. And this helps parents, maybe they're not getting along and their relationship is ending, but their co-parenting relationship remains. And so having children be the forefront really helps lower conflict. So less time, less money, less conflict are the three main reasons to mediate.
And really what that all culminates in is better for kids. And I know that I speak for both of us when I say that is what motivates us in our work. We have 50 years of psychological research that supports the notion that divorce in itself does not cause long-term emotional and psychological issues in kids. It's not the divorce, it is continuing conflict during and after divorce that creates long-term emotional problems in kids. Now, short-term problems are normal for kids in any divorce, but what we know from mountains of research is that where parents are able to find closure on their conflict, cooperate, communicate in a healthy way as co-parents after divorce, kids are extremely resilient, and we are not finding through many years of research long-term issues in kids. It is the conflict consistently that is creating, in some cases, severe emotional problems in kids, and that's where mediation comes in. It comes in at the pinnacle of conflict for these people. and gives them a space to actually communicate, control their agreements. And through this conversation, like Karen mentioned, we really are using the same techniques as many of you use. We are normalizing on a constant basis for clients, and we are in a constant state of reframing. If there's one strategy that I use more than anything, it is reframing, because no matter what it is that one person is saying, I can refilter that in a way that the other person can hear it better. And so really, in so many ways, the mediator acts as a filter, so that each person can hear the other person in a more positive, more productive way. That's how we're able to make progress and reach agreements that work for both of them. Certainly keeping a future focus, not getting bogged down in the past, mutualizing, bringing them together, same boat, um, same problem. Let's focus on solving it. So many of the same interventions we're going to use to lower their conflict. And we hear again and again from parents who are divorcing that they communicated in a better way in mediation, getting divorced, than they had in the 10 years prior. We see that as a big positive for them. They still may need to complete their process, but now they've had the experience not only of reaching their agreements, having a shorter, lower cost, less stressed process, they're actually going to use this experience in the future. It's going to help guide them in terms of how they talk in many ways after the process is over. So you are getting a sense of the mediation process, how mediation works, raising issues, explaining law, helping guide and facilitate a conversation and reaching agreements. You're getting a sense of the timeline. We have 2-hour meetings. They're going to set the pace. They're going to have anywhere from 2 meetings on the low end to 7 or 8 meetings in very rare cases where they need that time. And like Karen said, it's going to happen in a matter of 2.5 to 4 months for many of our clients. That is a fraction of the time that we see this take in the courts, many cases taking well over a year. So you're getting a sense of the timeline now.
Well, I think it might help to, when we say our process in mediation and how it's different from litigation, you're saying we're raising the issue, we're telling them the law, and we're helping them have a conversation to reach agreements. Can you give us an example, maybe in a parenting plan, what that would look like played out in the room?
Sure. So it could be on any issue. It could be on parenting time. Okay, and parenting time. We might have a 2-year-old and a 5-year-old. And it might be that one parent comes in and says, I think I know what we do in terms of sharing time. We should have every other week. These kids should be a week with mom and then a week with dad. And the other parent might say, oh, no, that's not happening at all. I'm going to have them during the week, and you can have them every other weekend. So what you have here are parents with a very different idea coming into the mediation of what it is that they think is best. Now I'm going to ask questions. I'm going to ask the person who proposed a week on, week off. Tell me what some of your goals are. Tell me what you're trying to accomplish with that agreement. And they might say, gosh, I'm trying to accomplish consistency. I want the kids to have something that's consistent. And I also really want to spend equal time with them. I think that that's very important. Okay, all right, good. And I might ask the other parent, can you tell me about some of your concerns? And some of the things on your mind, saying that they're going to be with you during the school week and with the other parent every other weekend. And they might say, well, I'm always the one who does the homework with them. And the other parent really isn't involved in their day-to-day when it comes to taking them to doctor's appointments and things. And so I just assume that's gonna continue. And now we've set up a way to have a conversation to actually explore these things a bit more. I might ask the other parent, can you tell me a bit about what your goals are for your investment in spending time with the kids Are you planning on doing homework with them during the week? Are you planning on taking them to appointments during the week when they might be with you? And so now actually we're going to get them talking. That parent might say, yeah, I wish I was there more during the marriage. I admit that I wasn't, but I want to do more now. Bittersweet for you to hear, other parent. I'm sure that must be tough, but you're hearing that. Are you open to this parent taking the kids to appointments and doing homework with them? Well, yes, I am. I wish it would have happened during the marriage. Okay. So now we've got them talking. And so now I can even provide some education. And once they might be in agreement that, okay, the goal is to share equal time, and the goal is to communicate about homework, and the goal is to share all of this information about, doctors and third-party caregivers and whatnot. Once we get there, now I'm going to provide some education. We're going to look at the proposals. Well, I hear your proposal a week on, week off. It might be good to give you an idea of, where kids are at 2 years old in terms of their developmental capacity and what they might need to feel safe spending time with each of you. Frequent, continuous contact is going to be important the younger the kids are. I might explain that. I might explain conventional wisdom, Karen, is that really the age of the child should be consistent with the number of days that they're away from the other parent. So if a child is 2 years old, if we're saying, okay, healthy attachment to both parents, the goal is bonds with both parents, really don't want to see much more than 2 days apart. A 3-year-old, you wouldn't want to see much more than 3 days apart. So we're giving information, we're educating, we're continuing that conversation, and they wind up maybe with a plan where for the first few months, they're with the parent who's been the primary caregiver a bit more. There's a few days between. And then once that goes well, the parenting plan shifts to an equal plan. Maybe that's a 2-2-3 plan where they're with one parent for 2 days, they're with another parent for 2 days, and they share the weekend with the first parent. 2 days with one parent, 2 days with the other parent, and the other parent has a weekend. And so it's a very organic process. It can move people in very positive, productive ways to agreements that are not only agreements that they are both understanding and owning and informed about, but that are better for their kids. And if our number one goal is for them to reach the best possible agreements on all issues, our number two goal is advocate for what's in the best interest of kids. At the end of the day, they are in control of their agreements, but we're going to help create the environment and also educate and give information to empower them to make the best decisions for their kids.
What Michael's really doing is a few key things here. We call when our clients come in and say, I want full custody, and the other spouse says, I want full custody. We call those demands. I demand full time, I demand full time. And what happens, it's like that Chinese trap. When you pull, there's more tension. And so what happens is, well, nothing happens. We're not getting anywhere. And this is how court battles begin. And what Michael's doing is a term in mediation we call interests. So it's called interest-based negotiation. And what we're doing is we're trying to get under the what we want, I want full custody, I want full custody, to the why. Why? And this is what causes conflict. Our spouses do not understand the why. Many of us do not. When our brains are in conflict and we're in fight or flight and we're going through traumatic events, we're not able to understand truly why we need something. And if we can understand why we need something, we'll be able to reach agreements. For example, we'll call him Bill. Bill wants an orange. And Jane wants an orange. And they are best friends and they're fighting over this orange. Bill says, I want the orange. And Jane says, no, I want the orange. And well, they both want the orange, so nothing's going to happen. They're fighting. But if, like we do in mediation, we start to understand, okay, why does Bill want the orange? We find out, well, Bill doesn't want the whole orange. Bill wants the orange because he wants the orange peel. He's making orange banana pie, right? And he's using an orange zester. He wants orange banana pie and he needs that peel for the orange zest. And Jane wants the orange, not for the peel. Jane wants the orange because she's juicing. She's loving juicing and she wants that orange juice.
Mm.
But when they're saying, I want the orange, no, I want the orange, and they're going at it like that, they'll never know that Bill wants the peel, Jane wants the juice, and they can reach agreement. And so that's what Michael is doing in mediation. He's finding out, well, why do you want full custody? Why do you want full custody? And how can we figure out a way to meet in the middle that works for both of you? And that is the example of the orange peel. I hope you enjoyed it. Second,
I enjoyed it. I am hunkering for some pie right now. That's what is anyone else hungry for pie? I sure am.
thanks, Mike. I appreciate that. I'll send you the recipe later. Actually, so we live together. We'll make it. Orange zest banana pie.
Here we go.
And second,
Did we share? We should share with people that we're married.
oh yes, we're married and we like to put on, CEs for therapists that we love.
Yes, we do. Apparently, I think it's going pretty well. Send the feedback to michael@oratmediation.com or Karen@oratmediation.com, or just CC us both. We'd love to hear back from you at this point. So far, so good. Okay.
And the second thing that Michael was doing, we call preempting. We provide our clients with education. This is something that does not happen in the courts. It's because of the research that we know, and because we know that providing education on child's needs from birth to 2 years old, from 2 to 6 year old, we know that that's going to have a significant impact on the agreements that are reached. Parents don't always know, okay, at this age, at this age, being a toddler, you need constant contact with both parents. And so by letting them know that, it does make a difference. And we are always doing that, providing education for our clients. And finally, what Michael's doing by helping them reach agreements, creating this positive area and creating a positive outlook, it does impact. Actions affect emotions. Behavior affects emotions. And so clients see that they're reaching agreements, and it helps motivate them to reach the next agreement and the next agreement.
It's exactly what's happening. And so commonly we see people who start mediation and go into it with an attitude of, we are never going to be able to reach agreements. We're just not, we don't communicate. We're at opposite ends. The other person's already threatened X, Y, and Z is going to happen. We are so far apart. And in almost every single case that we mediate, they reach full agreements. They get there. And it is very much that momentum that helps get them there, Karen. You're absolutely right. And the anchoring, right? When we're able to anchor in, whether it's the law or whether it's in, even more meaningfully, a piece of scientific research, and where we're able to anchor in it before either of them stated their demand, it recalibrates the conversation, right? If they're each about to make a demand that's extreme, but the mediator begins with a piece of research about what kids actually need on this issue, oh, I've anchored in that. That's a strategy in mediation. I've anchored in that. I'm not saying they have to do that. I'm just providing the information, and it's going to really affect now their potential proposals, what they're going to be asking for, and it's going to affect and color that conversation. So that's what we mean when we say guided process. We are absolutely guiding them through this conversation by conversation, issue by issue. So really getting a sense now, we hope, of mediation process, of the timeline, of some of the technique and strategy, the conflict resolution technique that we're using inside the mediation room. You've understood now some advantages of the process and research that we understand related to kids um, and and divorce. That it is the conflict, not the divorce itself, that creates long-term issues in kids. Like to go over now some key points in the agreement to begin mediation that we actually signed together with our clients. They really outline, and some of this will be a summary, the pillars of mediation, the core pieces of mediation. The first being the impartiality, right? The neutrality of the mediator. The mediator is not taking sides, although the mediator at the Art Center is always going to be an attorney. We're not acting as an attorney when we're with the clients. Attorney hat is off, mediator hat is on. I like that hat. It fits really, really nicely. And so I'm not taking sides. I'm working with both of them, for both of them, to help them have these conversations and reach agreements. And I'm also balancing. Okay. It is a rare case that both people in mediation have the same exact level of power. When you talk about power dynamics, and all of you therapists understand who work with couples that there are different power dynamics at play. One of the things that we're doing as mediators is balancing that dynamic. So we're balancing their dialogue, balancing their communication, so that both people have a voice, so that both people have a space to feel comfortable. If we have to, although we will be meeting with them together, we may even do a breakout so that someone who might be having some issues finding their voice is able to just speak with the mediator privately so that they can communicate what's important to them and why. And so there is flexibility in mediation to ensure that the communication is balanced, to ensure that the understanding of the law is balanced, and in the end, to ensure that each person is exercising their self-determination, that they are entering into free, voluntary agreements that they want to enter into, that each of them believe is the best agreement that they can come to, and that that agreement is better than what would happen in court. So impartiality of the mediator is going to be very important, with balancing work to make sure that both have a voice. Self-determination is going to be absolutely key, right? Each of them having control over their ultimate agreements, not feeling intimidated by the other, feeling like they are exercising what they believe is best. And confidentiality, Karen touched on it for a moment. Arizona protects confidential communications and mediation. Anything said in mediation stays in mediation. It can't be used against the other person at some later, court date. And it really allows that confidentiality for more open, honest conversations to happen without fear that it's going to be used against the other person. Disclosure, they each have to disclose their documents. That's another way to even the playing field, especially when there's an imbalance of knowledge of their financial information. They're going to have to, by Arizona law, even in mediation, share their bank account documents, share their retirement documents, so that each person knows exactly what the financial state is and what the history has been financially.
That's an important point to note, Michael, because that's a question I actually get asked from many therapists and many other professionals. Is mediation, would it be the same? Are mediation clients held to the same standards? as litigation, yes, disclosure, you need to disclose just like in litigation. Same issues, same disclosure standards to go through mediation and with attorneys, just lower conflict.
Good. Really, really good. We also have a set of guidelines, that are going to keep us on track. We're going to go over those guidelines with clients right at the beginning of mediation. And the guidelines really start with the golden rule. Aretha says it well, RESPECT, respect. We've got to show respect for one another in these meetings. There are heated moments. There are times where conflict can escalate. And what the mediator is going to do is remind in a gentle, kind, compassionate way that we have these guidelines. We've agreed to treat each other with respect. And so that really is kind of the guiding light of our guidelines. We take the playbook, a page right out of the therapist playbook, and we explain to clients that we want to try to use I statements rather than you statements. That someone's saying about something, I really want this because I think I need that. And I feel like this is fair because of X, Y, and Z. Well, saying that to someone is going to be responded to in a different way than if someone had said about the same thing. You are going to give me this because you did that. Now you are going to be the one who, whoa, different reaction, a different conversation. And the point I make to clients right before mediation begins is it may even result in a different quality of your ultimate agreements. How you talk to each other, how you show each other respect in these conversations will directly impact the quality of your agreements. Very, very key guideline. Of course, they're going to refrain from using inflammatory language. They're going to refrain from interrupting each other. They're going to attack problems rather than attacking each other, because there are going to be problems. There are going to be disagreements. If you have clients who are really having a ton of disagreements, that doesn't mean they're not right for mediation. All of our clients in some way or another have some kind of disagreements, and many have huge disagreements. Here's the key. Let's get the disagreement defined. Let's understand exactly what they're disagreeing on. Oftentimes it's just a misunderstanding, actually. And once we understand, they align just because now they know what the issue is. But let's define that problem, that disagreement. Let's put it on the table and let's focus on the disagreement. Let's not attack the other person. Okay, and we explain that, and we educate clients on that at the beginning. We educate them on interest-based negotiation, exactly what Karen touched on earlier. And we do a lot of acknowledging. In the guidelines, we acknowledge that there is a history between these people, between these spouses, between these parents. There's a history, and they're entitled to their own truth. They have their own perspective about their history, about their relationship, and they actually don't have to align on a shared sense of history to be able to be very successful and reach agreements today that are so necessary for them to allocate their assets and debts, come up with support that's going to be something that makes both of them financially stable, and develop a parenting plan that's best for their kids. They don't actually have to align on certain things from their past to reach great agreements today that are going to be good for their future. So that gives you a sense of what we're doing in the room with clients. Karen, how much time do we have to maybe answer some? Go ahead.
We're just about ready to wrap up, but it's really good to know. You might be thinking, what are my next steps? How would I get one of my clients to mediation in order to lower conflict? As therapists and mediators, we have a goal, a mutual goal, and that is to lower conflict and help our clients with whatever is healthiest for them. So in this case, we offer a 1 hour, sometimes it can be more depending on questions, complimentary consultation. And what we do is we offer this consultation for both spouses. Because mediation is neutral, we do want them to start off on the same playing field, on the same level, knowing that they're hearing the same information and that we're neutral. And so we bring them in, they don't have to be getting along, they don't have to be wanting to talk to each other, they don't even need to know if they want to do mediation. We bring them in and we go through an overview of the mediation process. We tell them about our values. You know, we're simple, we have a simple process, a caring process, strategic, we're positive, we're honest, and we're mindful. So we guide them through what mediation looks like coming through our process, and that they don't actually have to fight in court. So we compare it to what litigation would look like for them and give them any information that they would want to know. So that would be the first step, is contacting us for a complimentary consultation. It's just information, and they can choose from there whether or not they need to move forward, if they would like to move forward. And that would be the next step. And what we get a lot is, what if one spouse does not want to attend? And so that's completely normal. What we would do is send the other spouse information and let them know that we're always here to answer questions, and that the complimentary consultation is just information. And so that takes off the pressure of attending, where people know they're not signing anything. It's just to come in and learn more about this process that many feel so in the dark about.
The truth is, spouses are never in the same emotional place. They are never at the same stage of grief on the Kubler-Ross scale. One person is very commonly, at more of a place of acceptance. That's the person who's initiating the divorce, while goodness, the first person is just freshly understanding that this is a reality. So because we see people at different emotional places, we see different levels of readiness to attend an initial consultation. And we see that also affect our work in mediation, although what we see most often are people in mediation getting to the point over the course of a few months of where they are more aligned emotionally. There is the reality that they both understand and accept. They've been given a voice and an opportunity to control, both of them, their future. One person may believe, I'm not in control, that the divorce is happening. And that's true. Arizona is a no-fault divorce state. That means if one person chooses to move forward in a divorce, the divorce is happening. There's nothing that the other can do to stop it. But there is a tremendous potential to controlling their actual lives, their actual agreements that are going to affect their lives, and they have complete control over that. That's something we explain that I think brings a sense of relief to people, even at the beginning of their process, if they understand that.
Michael, one more thing that brings relief that is good for all of you to know is that during mediation, we provide our clients with what's called a preferred legal advisors list. It's a list of our most trusted attorneys. They are very mediation friendly and believe in the mediation process. And although we have licensed attorneys guiding them through their process, we give legal information. We tell them the law and help them have a conversation. We do not provide legal advice. And so some clients feel the need to know more, feel they've been in dark about their finances, for example. What are my rights? Will I know this going through mediation? Absolutely. So what they can do during mediation is call one of the attorneys from our preferred list, or if they have another attorney they'd rather use, that's completely fine. Our attorneys will work with them hourly. They will not charge that high retainer I spoke about earlier, $5,000 to $15,000. They will work with our clients and provide legal advice at an hourly rate. So they can use the attorney as much or as little as possible. They may use the attorney to get advice throughout the whole mediation about everything, or they might want their attorneys to just read the final agreement and make sure that everything makes sense. They've dotted their I's and they've crossed their T's. So that is a phenomenal service that we do provide, and that helps our clients feel safe.
Excellent. If you have any questions, if you've listened to this hour-long program and you've jotted down a list of questions, we would love to answer them. You can feel free to reach out and email us, and we can either connect via Zoom. We can come and do an in-service, more advanced continuing education program for you and your own team if you work with others. We are here to support you. I love therapists. Obviously, I even married one. And so we want to end by thanking you. Thanking you for the services that you provide for the families that we work with. We know when a couple has worked with a therapist, either individual work or couples work, doesn't mean that they're necessarily the most amicable, but they understand important ideas about what healthy communication looks like and what self-reflection looks like. And that's the work that you're doing with them. So we are grateful for you, the incredible work that you do with clients. And we are here to support you in any way that we possibly can.
Absolutely. And we love that we have shared mutual goals for our clients with therapists. And also, we are always looking for therapists to refer our clients to. We have many reasons why we may want to refer child therapists or help processing through the divorce, which we are not doing. We're not helping them processing like you all are. Sometimes they need to go to counseling because they don't actually know if divorce is what they want. So we have a therapist list, but we would love to meet with you and hear about your practices and hear what you do and how we can collaborate and work together and make sure that our clients are getting the best care with you. So feel free to always contact us. You could either call us or email us. It's Karen, my name, at artmediation.com or Michael at artmediation.com. And we can always meet either in person or my favorite Zoom coffee and talk about how we can also support you and our clients at the same time. So thank you so much for coming today. And we are always here. If you have any further questions, we're happy to spend as much time as needed to help answer any additional questions you have. We're so grateful for our therapist community. Thank you very much.
Thank you very much.
Take care. Bye-bye.